Greetings, my fellow freedom lovers and sovereign thinkers. This is LL3's latest podcast. My name is Craig. I am presiding among the beautiful swampy mangoes of South Florida. It is an evening warm time. I don't know why I use that lingo, but forgive me on that. And I'm going to do a couple more episodes, or actually articles. And it's both from proliberty.com, and I thank them for sending me the email, because they're very interesting subjects. And one is called "The Supreme Court Strikes Blow to Fourth Amendment with Homeowner Consent Ruling," and as America's statists work to destroy gun rights, Embattled, Ukrainian citizens demand a version of the right to bear arms. So I want to do the Supreme Court version first, and if I'm correct, this one is written by Ben Bullard, and you could subscribe to their email and go to personalliberty.com for more information. I do recommend them because they are very good. And that's it for them on that perspective note. So I'll just start with the first title. Supreme Court strikes blow to Fourth Amendment with homeowner consent ruling. This was published February 25th, 2014 to be exact, which is cool. So this came out like a couple of hours ago. The Supreme Court ruled today that police without a warrant may legally enter and search a dwelling even over the vehement protestations of an occupant, so as long as a co-occupant grants them access. That decision reverses a 2006 ruling which held that the refusal of even one occupant to allow a warrantless search was sufficient to keep law enforcement from entering a home. Today's ruling in Fernandez v. California was handed down in a 6-3 opinion. I like when you say opinion. Good grief. Led by Justice Samuel Alito, writing for the majority. The case involved an LAPD search of a house they believe harbored a robbery suspect. The suspect, Walter Fernandez, wouldn't let them inside the house, but the police argued that Fernandez's girlfriend, Roxanne Rojas, looked sketchy enough to suggest a probable cause for domestic violence, an unrelated charge. Thought crime, 1984. They went and arrested Fernandez on the DV charge, removed them from the home, and in the meantime sought and got on-site permission from Rojas to search the home. That search produced evidence that tied Fernandez to the robbery, the reason the police had shown up in the first place. Writing for the majority, Justice Samuel Alito argued that Rojas' permission carried equal weight, really greater weight, with that of Fernandez's denial. A warrantless consent search is reasonable and thus consistent with the Fourth Amendment, irrespective of the ability of a warrant. Denying someone in Rojas' position the right to allow the police to enter her home would also show disrespect for her independence. Compare Alito's words with those of retired Justice Dave Souter, who wrote the majority opinion, which is linked for a similar case with very different outcome. In November of 2006, it says the pragmatic decision to accept the simplicity of this line is moreover supported by the substantial number of instances in which suspects who are asked for permission to search actually consent, albeit imprudently, a fact that undercuts any argument that the police should try to locate a suspected inhabitant because of his denial of consent would be foregone conclusion. This case invites a straightforward application of the rule that a physically present inhabitant's express refusal of consent to a police search is dispositive, that is, settled and absolute as to him, regardless of the consent of a fellow occupant. It appears evident that the police got their man, and no one is bemoaning a travesty of justice for a man whom evidence suggests had committed a crime. But today's ruling is a backdoor way into people's homes, one without a guarantee that law enforcement will always be in the right. It invites the police to escalate impromptu searches by keeping them persistent at a dwelling until they can get what they came for. It creates an invitation to law enforcement to find anyone living in a home whom they can convince to grant them access after first being explicitly refused access by another occupant. Whereas Souder and the majority found in 2006 that one refusal was enough to force police to demonstrate probable cause to search your home, Alito has invited the police to go fishing for most gullible and legally naive resident who might be found at the premises. All they need is a yes, and any yes. Well, Ben Bullard is right on that. And for that link on like a majority opinion, if I'm correct, that's under findlaw.com. Yeah, findlaw.com, but that's a very good website too. You know, just go Find Law for legal professionals. And they do have, regular consumer and membership, special membership, etc. However, I have to agree what Mr. Bullard said on here. It is very disturbing. The one thing I always tell everyone, ignorance of your rights is no excuse. Like ignorance of the law is no excuse. Ignorance of the Bill of Rights, natural born rights, or your state constitution, Declaration of Rights, or Bill of Rights, that's under that as well, is no excuse. Everyone has an obligation to know them. Don't go, I assume. You practice it. It's like reading the Bible or auto manual, computer manual, etc. You want to practice it consistently every day. Then it can really absorb in your mind beneficial basis. That's what you need. You have to practice this. And even if you have your girlfriend, your wife, or a guest, you need to let them know about this, about the police. If they said never let them in. If they go, can we come in? If you're not so sure, ask me. That's one figure of speech. You let the other owner, occupant know. Don't you ever give them an answer of letting them in. Because people have done it, and people complain about it. I go, you know what? You have a yes person in there. Why? Because they may wear a uniform. They can do whatever they want. The fact is this. Good example. If an officer stops you and asks for ID, you can reply, what's the nature of this investigation? He has to answer it. If not, you have the right to remain silent, period. Alright? Texas versus Brown proved that. Around 1981. It went over, it started from El Paso, the courts in El Paso, Texas, the state Supreme Court, and went to the U.S. Supreme Court, and he won. Mr. Brown won that case. You need to do it in here as well. And if you're not so sure, look at the U.S. Constitution, Amendment 4, all papers, houses, effects, which is property. They need a warrant, Fourth Amendment warrant. Of course, the Ninth Amendment as well. Enumerations, natural law, laws of nature. That's your lair. They have to respect it. There are no exceptions. In addition, go to the state constitution. They have particular language about searches and seizures, properties, and so forth. Good example: state of Florida, Article 1, Section 12 is equivalent to the Fourth Amendment of the U.S. Constitution. So that's the lesson you have to learn. When you have a facility or home or lair that has co-occupants, better start having this discussion, because what's been going on they're actually trained to quotabate how many people they could arrest, how many tickets they could put out. That's the lesson for this particular case. I don't like it, but knowledge is power. Knowledge is freedom. Ignorance is enslavement. And that's how my take for that particular article. And we'll hit this next one, which is entitled, again, An American Statist Work to Destroy Gun Rights. Embattled. The Ukrainian citizens demand a version of the right to bear arms. And this one was actually written by Sam Rowley. He's very good too. Same website, personalliberty.com. And today, February 25th, 2014. As it reads, America's founders so understood the important right to bear arms as a great equalizer between the political power structure and the general populace that they included the right in the Second Amendment to the supreme law of the land. Today, far removed from the bloody war for American independence, the sanctity of their right is lost of certain factions of the nation's population. They are working overtime to destroy it. Meanwhile, some Ukrainian citizens currently battling an oppressive government are calling for a version of America's Second Amendment to be added to their constitution. According to some watchers of the violence unfolding in Ukraine, between 70 and 100 protesters were murdered in the past week by government thugs and snipers seeking to quell the rising tide of the dissidents in the country. And as the country's disenfranchised masses continue to take to the streets of protest of government that fails to properly represent the will of the people, Ukrainian officials are likely to continue killing protesters with little threat of retribution from an armed populace. That's because, according to gunpolicy.org, long before the political unrest reached its climax in the country, legislation was produced to require anyone who wished to own a firearm to prove genuine reason to possess a firearm, for example, hunting, target shooting, collection, personal protection, security. Hey, you know what that means? Personal issue. What do you want it for? That's called a privilege. Alright, by government, which I say, Currently, the rate of private gun ownership in Ukraine, legally and illegal, is only about 6.6 firearms per 100 people, compared to the gun-loving United States, 100.05 firearms per 100 people. This week, the Ukrainian Gun Owners Association took the advice of America's founders and called for an increased gun rights for the nation's citizen. And the group announced via press release, that links to their website, and it says here, today, every citizen of Ukraine understands why our country has hundreds of thousands of policemen. Last illusions were crushed when riot police and rubber batons and boots at Independence Square on peaceful citizens. After such action, we realize that it is not enough to only adopt the gun law. As for today, Ukrainian Gun Owners Association will start to work on the preparation of amendments to the Constitution, which will provide an unconstitutional right for Ukrainian citizens to bear arms. The people should have the right to bear arms, which will be put in written in the Constitution. Authorities should not and will not be stronger than its people. Armed people are treated with respect, as the United States political machine increasingly demonstrates a will to operate as an entity over the people, rather than for and by the people, during an era when populist revolt against bad governance is occurring with increasing frequency around the globe. Is there any question about what's truly behind America's status efforts to destroy gun rights? Just ask a Ukrainian. Very well written, Mr. Raleigh. And it's a fact, my friends. And just to let you know,